Good afternoon, sir. So we'll be letting everybody in a minute at 3 o'clock, and then we'll hand it over to the moderators and the participants.
Thank you.
Sir, I think you can let people in now.
Okay.
Okay, we'll start with the workshop. So first of all, a very good afternoon to respected Advocate Sanjay sir, all the participants in this workshop. First of all, I would like to welcome Advocate Sanjay sir for accepting our invitation and being part of this workshop. So it's a great honor for us to listen the knowledge regarding cross-examination. I also like to welcome all the participants for this workshop. I would just like to add that what Bentham has rightly pointed out, that witnesses are considered as the days and years of justice. And it is the art of cross-examination that helps the counsel to put forward his case, to elicit positive facts from the witness that should come before the judge. And his skill of cross-examination would help him in becoming a good lawyer. I would again like to welcome all the participants into this workshop. Thank you. Over to you, Aniket.
Thank you, sir. Thank you for addressing all our participants and welcoming all of them to the session. So I'll just give a brief introduction to the session and what we'll be doing in this workshop the 2 days. So basically, to speak a bit about the workshop, it aims to educate the participants on the different facets of cross-examination, covering the law and the practical aspect. Cross-examination plays a vital role in giving credibility to the testimony of witnesses. Though law students are exposed to cross-examination in criminal law, an awareness regarding the procedure and some important practical aspects are left out. This workshop looks to cover that gap by ensuring that the participants know how a cross-examination happens in the court of law. On the first day of the workshop, we would be looking to understand the legal provisions and the manner of cross-examination. We would be dealing with the aims and objectives of cross-examination, why and when it is required, legal provisions related to cross-examination, and finally, the procedure and steps for conducting the cross-examination. On the second day of the workshop, we would be dealing with the hands-on experience of our esteemed speaker, Sanjay Vasishtha sir. And through his experiences, we would educate the participants on the common errors committed in conducting examination and cross-examination of the witnesses. Further, the session will highlight the importance of recording examinations and how they can be recorded in a court of law. Moreover, it will talk about the powers of advocates and the power of judges to recall or re-examine witnesses, the key strategies and pointers required to be prepared by the advocate, and the importance of recording examinations and its procedures would also be dealt with in great detail. I now ask Meenakshi to come forward and give an introduction about the speaker as well as the house rules.
So first of all, good evening, everyone, and we're glad to have you here for the session.
I think she's having a bit of a network issue, so I'll just introduce our speaker. So Sanjay Vasishtha sir is an LLM in comparative law from McGill University, Canada, and an MSc in criminology and criminal justice from the University of Oxford. He is a practicing attorney at the Supreme Court of India and a visiting lecturer of criminal law at Lloyd Law College, Noida, and the course instructor of criminology at Eastern Book Company. He continues to be affiliated with the University of Oxford as a research associate with the Department of Criminology. Mr. Vasishtha is actively involved in various human rights projects across India. He is the founder of the think tank Disability Rights and Mental Health Research Foundation India, launched with the quest to address wrongful convictions and provide better access to the criminal justice system for persons with disabilities. Mr. Sanjay Vasishtha has published extensively in prestigious national and international journals and platforms, including Oxford, York University, and so on various topics such as repatriation for the victims of gender-based violence, acid attacks, policing, etc., and has successfully argued several noted matters before the High Court of Delhi and the Supreme Court of India. He is a member of the Supreme Court of India Bar Association, Indian Police Institute, Innocence Project, and affiliated with the University of Oxford as a research associate. We are extremely delighted to have you as a guest speaker, sir.
Thank you, Anik.
So I think Meenakshi is back. She'll be dealing with the rules for this session.
Apologies for the network issues from my end. So as Aniket said, we're very happy to have you here for this session, sir. Following to the house rules. So there'll be a question and answer session at the end of today's session, where the speaker shall address the questions from the participants. You may drop your doubts and questions in the chat box so that we shall take further questions to him during the Q&A session. However, you are also allowed to ask your questions directly to the speaker during the session. So in that case, you are requested to unmute yourselves only when necessary and raise your questions. Participants are requested to remain on mute otherwise, and you can switch on your videos if you want to. We would also be circulating a feedback form in the end of the session tomorrow. All the participants are requested to fill the same. Thank you.
Thank you. I think, shall I begin?
Yes, sir. Yes, sir.
Let me, at the outset, thank Dr. Syed, if he's still with us. I am always curious as to how Dr. Syed pronounces his first name. It's a very interesting name.
Sir, it's Hifazat Ali Syed.
Hifazat Ali, wonderful name. I was waiting to ask you this question. So wonderful to meet you. And thank you, Aniket, Meenakshi, for the introduction. I believe you have got this introduction from a private website somewhere. It's been a while. Let me just give you some background of what I do now. This is what I did in 2014 or 13. So I also serve as a counsel for Delhi Police. I'm also a lecturer with Delhi Police, other than being a standing counsel here in Delhi High Court and Supreme Court. So I've had the privilege of being a defense counsel. And luckily, on the other side, I also represent Delhi Police in various capacities, other than my role as a faculty there at Delhi Police Specialized Training Center, where I'm lucky to, in fact, learn a lot. I always look forward to learning something back from these seminars and lectures, like I look forward to learning something back today. Now, when I got this email, asking me to speak on this very important topic, I remember late Mr. Ramjet Malani speaking at the Supreme Court Bar Association in 2014. See, this art can't be mastered. All we can do is to practice. And then the practice would only happen when we attend trial courts. It's of course it's very fancy, to say that one is only appearing in landmark cases before the High Court or the Supreme Court, as my introductions highlighted. The fact of the matter would also remain that a good counsel, in my opinion, would have to start from a trial court, would have to be a great counsel at a trial court first, in order to be a good litigating counsel at the High Court and Supreme Court, because that is where you understand how the system works, how the witnesses think, and that is what is carried forward to the upper hierarchy, correct? So that is how we begin. Now, this topic, of course, I couldn't help but to immediately accept this. In fact, this topic was so close to my heart that I was otherwise going to be back from Bombay tonight. I came back a day before just to be with you, all of you here. And just came back, in fact, after cross-examining a witness today morning in a very in a 376 matter. Cross-examination, you would have a lot of books. Again, they are very, very important. You need to really understand the provisions of law, the substantive law and the procedural law. Like, you would have to understand, I think it's section 136 onwards, 136 to 166 of the Indian Evidence Act. Obviously, these are substantive and procedural laws. You need to really be aware of the law. That would give you an innate confidence. You would know. And if at any stage, Meenakshi, Aniket, if at all anybody feels that I'm going too fast, you please feel free to intervene and let me know, because see, I take certain things for granted, right? Whereas our audience would have to understand the basics at the outset. And obviously, Aniket has already made it very clear that we will discuss the theoretical aspect today, and tomorrow I will have some of my own cross-examinations displayed on the screen. We will understand how cross-examination is actually done and what is the outcome of all these proceedings. If there is a student who can Google a case which is reported in AI or SCC, I'm happy to bring those cross-examinations as well. There are cases which eventually went all the way up to the Supreme Court and the acquittal or the conviction was confirmed. Now, that is also an option. What is this art of cross-examination? Why is it necessary? I think the most basic question would be, the most basic answer would be to obviously reach a logical conclusion in terms of a trial. Now, obviously, we know that there are, procedures in terms of 482 CRPC where quashing may happen. We know that the FIR, which has been filed by the complainant, victim, anybody for that matter, there are complainants such as, investigating officers are complainants in certain matters. There are private citizens who are complainants. One may prefer quashing, but quashing again, quashing of an FIR, quashing of a charge sheet, all these procedures again are before the constitutional courts. You really don't cross-examine anybody. That is not a quest to impeach credibility of any witness. But let us understand what is examination in chief before we come to cross-examination. What is happening and how does it start? I'm given to understand that most of us have some basic understanding of the administration of criminal justice. Is that correct? Or do we start with the very basic of explaining as to what an FIR is? And we can perhaps, we can start quickly by sharing some inputs into the process itself. Let us understand what this process is. Now, how is the criminal justice system set in motion? Let us begin by discussing the basics. And we will discuss it all the way to the stage where the examination in chief and the cross-examination is conducted. So let us begin as to what really happens. In common parlance, let's talk about penal law in terms of Indian Penal Code. There are special penal laws, there are general penal laws, there are special penal laws like POCSO, prevention of children, right? Or the sexual assault. Now, POCSO is one law where, we have a special fast track court and all those things. Let's say there's a complainant in a 376 matter. 376 Indian Penal Code corresponds to rape, assault, right? The complainant goes to a police station or calls the police over. She narrates the entire incident or takes it to the police station in the form of a written note or a typed format, goes to the police station. The complaint is converted to a first information report under 154 CRPC, that is the Code of Criminal Procedure. In such sensitive matters, the first step or the first stage is to record a statement under 164 CRPC. 164 CRPC is the statement of the complainant. Now, obviously, it's a very sensitive crime. It's a crimes against the society at large. The magistrate would record the statement under 164 CRPC, and the investigating officer is usually asked to be outside the place where the 164 statement is being recorded. What is this 164 statement? It's recorded by the concerned magistrate, and it basically narrates the entire incident. It is to ensure that the witness or the complainant speaks without any fear. That is the whole procedural background of section 164 CRPC, and this happens. Again, the investigation continues for some time. Let's say there are other key material witnesses, there are expert witnesses. Again, the prosecutrix in this case or a complainant in this case would be taken to a hospital. Now, when this complainant is taken to hospital, this doctor concerned will conduct certain medical examinations, and there will be a medical report to that extent. The medical report will also observe, the injury marks, if any, if the assault, the sexual assault was violent in nature, there would be certain injury marks, or otherwise there would be, certain backgrounds into the sexual history of the prosecutor, if at all that information is shared at that juncture. Other relevant aspects are taken into consideration. Let's say that the accused is apprehended in the intervening period. The medical examination of the accused is also carried out to see if he is capable of carrying out the assault, right? Therefore, the whole process involves several witnesses. Usually, they are from the prosecution side. I must be very, very fair to say this. Obviously, the investigating officer, in my opinion, if you ask me as a defense counsel, I think the kind of Indian system, the adversarial system that we have in India. So, there are two systems in the world. One is adversarial and then the other is inquisitorial system. In the adversarial system, the judge is a spectator. There is a prosecution and the defense. And the reason we have public prosecution, that is to ensure somewhat fairness, because public prosecutors are not running after convictions. There is a sense of neutrality over here, right? In the inquisitorial system, let's say you have the Mexican system there, you have a magistrate who inquires into. One of my batchmates at Oxford was a magistrate there, and I asked him once, what do you do? How do you go about it? And he tells me that we investigate and we play a very important role there. So according to him, that system is better because the magistrate himself or herself inquires into the nature of allegations, and that is the best way out according to their. So that is how the systems are. I'm not going to find flaws in this system or that system. Now, let's say, insofar as going back to my example is concerned, there are 2 eyewitnesses or 3 eyewitnesses who probably saw the accused with the woman, with the prosecutrix entering a certain place. The other witness saw the accused and the prosecutrix exiting together. And there is a witness who used to see or who had categorically observed the accused and the prosecutrix, or the accused follow the prosecutrix in the past. There may be certain individuals who are very keen observers, right? The investigating officer, the role of an investigating officer is to ensure that all these key and material witnesses are a part of the charge sheet. Now, also assume a scenario where the allegation goes on to say that the sexual assault took place inside this place, this room, this hotel, the owner of such place may also be a material witness. Now, ultimately, after the investigation process comes to an end, the investigating officer decides whether to file a final report in the form of a closure or a charge sheet in terms of section 173 of the Code of Criminal Procedure, 173 CRPC. Investigating officer decides. Now, what is a closure report? Where the investigating officer, after conducting the entire investigation, feels that there is nothing to prove, or no case is made out against the accused. One. Two, charge sheet, if the investigating officer during the course of investigation has found credible witnesses and material evidences to proceed with the trial, to appear before the trial court and to proceed with the trial. This charge sheet in the form of a final report is filed in the court. Not to get into the minor technical details of magistrate committing the case to the sessions court. Let's say the charge sheet, this entire report, we will share some of these details tomorrow. This charge sheet reaches all the way up to the court. First, the first stage is to, obviously, this is done prior to the charge sheet reaching the sessions court. Sexual assault, rape is a sessions trial. The accused is provided with a copy of the final report on the charge sheet. Usually it's a bulky document, but it would also at the outset highlight who the relevant witnesses are. Now, in this case, let's say there are 8 witnesses. The complainant, obviously the complainant will have to be a witness. The investigating officer who has carried out the investigation, usually there are 2 or 3 investigating officers as well. If one investigating officer changes, the other investigating officer is also called to the court. There are doctors, and we call them expert witnesses. You must also note down this terminology called expert witnesses, because we will also discuss how to examine and cross-examine expert witnesses. They are very, very important in terms of examination. Then you have other independent witnesses from the locality, the kind of witnesses we were talking about. You will have, a bystander, you will have a shopkeeper, you will have a neighbor, you will have a friend, somebody of that kind. And today, the way trials proceed, the way we see these trials proceed, you also have a lot of electronic evidences involved. You have a lot of data. You have WhatsApp messages. You have, the Instagram. The other day I was cross-examining somebody, and this issue of Instagram messages came up, and all those chats came up, and all those things. So there is a procedure under Section 65. We will discuss that tomorrow as well. Now we know that we have 8 witnesses, for example, in this given trial. Now the issue of cross-examination and examination in chief begins after the charges have been framed. Now the court will frame charges. They will prima facie see if there is any case to proceed against the accused. Now let's say the charges have been framed under Section 376 of the Indian Penal Code, read with 506 IPC. I will have to now what do I do as a defense lawyer? I will have to read the charge sheet. I will have to see as to how to, because see, let's say the complainant says that the so-called offense occurred on 1st January 1990. Accused says, no, I was not even physically present in Delhi on 1st January 1990. But the only issue is that this entire FIR is out of some vendetta. There is some financial, transactions, and to avoid that financial transaction, a false FIR has been registered again. This is what the accused has to say. Why is cross-examination the only tool to impeach the credibility of the complainant or other witnesses, and how do we go about it? We will try to stick to practice as close as possible as I can make it, even when I discuss theoretical aspects, because the whole purpose, again, we can always go back to books for all plain theory, which is again very relevant, and I encourage all of you continue doing that. Let us say that the prosecutrix of the victim in this case enters into the statement box, the witness box, as we call it in India. We know we don't have a jury system. In the West, there is a concept of jury system. I'm sure you might have seen movies where the judge would frame the question of law and the jury decides on the question of fact. There is a jury who would then decide whether or not the facts they highlighted by the defense are correct or not. But we don't have it. Therefore, it becomes altogether more important here in India to cross-examine properly and to understand the art of cross-examination in all its potential ways, and to also master the way how certain questions are to be put forward. There are certain things I always wanted to say on this subject matter. And there is no better way to say this. I think we all build our credibility as counsels in the court. And this credibility is the first cornerstone to begin with the examination in chief and cross-examination. Nobody would highlight this. But let me say this at the outset. If at all we start by asking questions which are irrelevant, questions which have no bearing with the issue at hand, questions which are totally misplaced, questions, for instance, in this case, which impeaches the character of a woman, which is expressly barred by law. If we do not study the entire brief properly, if we are not aware of the legal consequences, we are losing the seriousness that the court and the situation demands. And our questions are more likely to be overruled. So as counsels, first step is to understand that it is imperative, it is very, very important that we immediately get a hold, we get a complete hold of the case at hand. We are very particular about our demeanor. I have seen, unfortunately, in certain trials that where it was not a camera trial. Camera trial, the proceedings are conducted alone, and the bystanders, the spectators, other lawyers are requested to be outside the courtroom during the cross-examination. That trials where cross-examination would yield great results are ruined by asking immaterial questions which are time and again overruled. And obviously, the presiding officer of the court then also gets an idea of the matter at hand. And ultimately, the accused and his or her fair trial rights are obviously in jeopardy. That is one thing which you need to understand. Now, let's say we understand the demeanor part, we have read the file properly, and now the stage for examination in chief happens. Now, what is an examination in chief? What do we, obviously cross-examination cannot start like the way we see it in the movies, that somebody randomly comes to the court and this person is sitting there and there is a lawyer who is roaming around in the court and starts to ask questions, and then there is some emotional drama in the background. There is a formal process the way it works. It starts with examination in chief. Examination in chief is again under 137 Evidence Act. If I'm not wrong, I think it's section 137 of the Indian Evidence Act. Here, the prosecution would usually ask open-ended questions. Now, pay attention, and I request the participants, if at all they have any questions, if they do not understand anything, I think feel free to raise your hands or put the questions in the question box. I'm sure somebody will be able to ask us these questions. This examination in chief is the first step to begin cross-examination. I think there's a question, Aniket, do we take questions simultaneously, or how do you want to go about it?
So you can if you want to take the question now, or you want to have we'll have a question answer session at the end. So if you want to take all the questions at that time, we can do it like
all right.
We'll
do that. We'll do that because I'm sure there will be a lot of questions, and maybe we can begin the question answer in the end. But for now, we will continue for next half an hour till 4 p.m. and then the question and answer.
Okay.
Examination in chief is a process where the prosecution would ask open-ended questions to the complainant. Open-ended questions like, who are you, where do you stay, what do you do? The idea is not to lead the witness. The prosecution is supposed to enable the witness or the complainant, as we are discussing this hypothetical case, to elaborate on the facts and circumstances surrounding the crime. The open-ended questions would be like, where were you when this happened? What happened on the fateful day? What happened on the eve of 1st January 1990? What happened at, so and so? How do you know him? Do you know the accused? How do you know him? Has he followed you in the past? And while asking these open-ended questions, the whole story of the prosecution, the prosecutrix, the ingredients of the complaint would come out in the open. A decade ago, this would be, or maybe I would say, at least since I have been in this profession, I have seen cross-examinations and examination chiefs being typed on a computer. Initially, I had seen a few places where a typewriter was being used. It's much easier today because, see, we have the privilege of backspace. If at all there is a problem, it can be rectified. The questions can be fixed. But otherwise, that luxury is not available, was not available to the counsel then. Therefore, today, when we cross-examine a witness, students, it starts with examination in chief, as I quoted, and these open-ended questions cannot become close-ended questions. What is my role during examination in chief as a defense lawyer? You have to understand this first. I have to make sure, and it is very imperative, it is important to ensure that the prosecution doesn't start asking close-ended questions or leading questions, and that is expressly forbidden. What are leading questions and close-ended questions? Let us understand that also. Let's say I, as a prosecutor, start asking the complainant in this matter, is it correct that you have been assaulted by the accused, namely X? Is it correct that you were? So I am not allowing the witness to speak. I am putting words into the mouth of the witness. And as a defense counsel, you are duty bound to object to such conduct. The prosecution or the prosecutor can only ask open-ended questions in the examination in chief from all the witnesses. Right? So far, so good? Right. After this examination in chief is over, all the documents which have been collected by the investigating officer, all these documents which are collected by the investigating officer are again exhibited. We'll show how these exhibited documents, because these documents must be marked that these documents have been signed by the witness. These documents have been narrated, the content of the documents have been narrated by the witness. All these aspects are taken care of in examination in chief. Now comes the stage of cross-examination, and we will understand what cross-examination implies and what cross-examination means. As a defense lawyer, I will see that the examination in chief, and I can again share an example here, which I would anyways share tomorrow. In the cross-examination, this is my only opportunity, other than the fact if I really want to indulge into defense evidence at a later stage. There is a provision in the Code of Criminal Procedure. Even the accused can be a witness, as a defense witness. We can have defense witnesses and some documents and all. I'm not on that today. Cross-examination is the only avenue or arena for me to impeach the credibility of the complaint or the FIR as well. And I will have to start strongly by impeaching the credibility of the witness. Now, let me give you an example. In one of the cases, what had happened, one of the witnesses had quoted that it was around midnight on 3rd January 2015 when I noticed X had committed an attempt to murder on Y. By stabbing Y, in his abdomen. This is what a witness, and the age of this witness is 61 years. He's a tea stall vendor. And he says it's January, it's almost midnight. And he narrates, he's a very important witness. And in fact, he's the only witness who had seen the accused X stab Y. That is the whole case of the prosecution. He says that it was very unfortunate. I saw everything and I clearly saw everything and all and all. When I get the opportunity to cross-examine this witness, my first question again is on his memory. I know he's a 62-year-old witness and we are talking about early January, midnight. And when I talk about midnight, it's very important to understand that obviously light, natural light wouldn't be there. Artificial light would make a major difference, because again, to be able to identify an accused around midnight, these are all material facts, correct? And how do I impeach the credibility of the witness? I will have to go on to these tangents. I asked this person, this witness, and in the cross-examination, it's always better to ask leading questions only. You are basically putting your hypothesis into the mouth of the witness there by asking yes and no questions. Because if you allow, as a defense attorney, a witness to speak at length, you will not have an avenue or a forum to present your own case and to impeach the credibility of the witness. So you will have to ask leading questions, great leading questions, which will impeach the witness. This is how we start. Now, in this case, I asked this witness that you are a 62-year-old man. I'm sure you must be using glasses, correct? He says, yes, I use my glasses. Now, I know, there is either myopia or hypermetropia. I mean, not an expert, but at least we know that, there is either far-sightedness or short-sightedness, correct? He says, yes, I wear glasses. My next question is, on so-and-so date of January at so-and-so time, what were you doing? So again, this is not a leading question, but one has to, he said, I was packing up my shop. I was getting ready to leave when I heard somebody, and then I noticed that this person. My next question, because see, as a defense lawyer, there are days when I feel like even visiting the crime scene. If I do not make an endeavor in all the cases, in some cases where it's possible and I feel like going there, I do it. I asked this person, how far were you? He says, I must have been around, 300-400 meters away. I must have been 300-400 meters apart. And I was able to visualize this person. And this is what his build was. This is the color shirt, this, that, all those memories. It's always a problem when a witness remembers too much. That defies human logic and experience. I mean, we also have a terminology for such witnesses. They are tailored witnesses who have been, fed all this data, and they are eagerly waiting to say all these things in the court. Therefore, we are very, closely observing the kind of chief which is done in the court. If a witness remembers everything perfectly, that is a problematic witness. You have a right idea there and then itself. Now, my next question is, was there any street light there? And my suggestion is, in my case, is that there is no street light. There is a site plan. Usually the investigating officer will also provide you with a map of the crime scene, roads and everything, and the lights will be marked there. How many lights do they have? He's like, yeah, there's a light, but it was a bit further apart. He's agreed. See, I'm trying to impeach his credibility by highlighting all these environmental factors as well. Now we know that there was lesser degree of visibility because the light was a bit further apart. Here there is a 62-year man with problems with farsightedness. He says there was no light. I had prepared my examination, cross-examination in advance, a day in advance. News media will tell me that due to smog, it's a combination of fog and smoke, the visibility was restricted to 80 to 100 meters. This is what news articles would tell me. I asked him, sir, is it correct that there was dense smog that day? He says, no, there was no smog. I impeach his credibility by showing him news report. Has the science failed in that case? If there is no smog, because the media reports would suggest otherwise. Then he said, no, then there might have been some smog. The witness had initially stated that the distance between the witness and the alleged crime scene was at least 400 meter, 300 to 400 meter. The visibility was pertaining to 100 to 150 meters at max. In better lighting condition, it would be 200 meters. But we are talking about a midnight situation. Again, I show him this clipping. I show him this news article. On the basis of that, he tells me in a while that right there was smog. And then on me asking him that are you able to recognize everything perfectly at midnight in smog? He says no. See, I'm asking him leading questions. Pay attention to the concept of leading questions that I'm putting forward. I ask him, is it correct that no human can then obviously point out everything with perfect detail if the visibility is reduced to 100 meters in this case? He says, yes, you're right, sir. Humans are not machines. There may be technical. And then my last question to him was, then is it correct that you may have also committed a mistake in identifying the accused owing to smog, lesser light? Then he's like, maybe I might have also committed mistake. Now we have a case. Did you all, I'm sure all of you heard me well. We impeached the credibility of the witness in this cross-examination by asking scientific questions, by asking questions which are a part of everyday human experience, by understanding the file properly, by reading the crime scene properly, by understanding the kind of questions, by looking at the time, by looking at the hour when the alleged witness said that this offense had been committed. Mr. Gopi Karunakaran, we would request to you to either turn your video off because there are younger participants observing this. It's already you're on mute, or you may just do away with that thing. Anyhow, to continue. Now this cross-examination happened and this witness did not turn hostile as such, but the prosecution says that the witness has turned hostile. Now let us understand who a hostile witness is. We will discuss the kind of witnesses and their examination in chief and cross-examination. The prosecution of the public prosecutor has a charge sheet, has a final report. This charge sheet says that Mr. A was also, in the other example that we had discussed, had seen the prosecutrix and the accused enter into a room at 3 p.m. on 1st January 1990. This is what the witness A stated before the investigating officer when the charge sheet or the investigation was being done. However, when the matter reaches the trial court, this witness has forgotten everything suddenly and says that I've never seen this so-called individual. I don't know who this accused is. I've been forced to say these things. Here, this is a perfect example of a witness turning completely hostile. How does a witness turn hostile? When, according to the prosecutor, the witness has deviated from the statement that the witness had rendered during investigation. And here the cross-examination is simultaneously conducted by the public prosecutor in this case. We will also share an example on this subject matter. Because, see, the defense lawyer doesn't need to do much in this case, correct? Because the witness has already done what the defense had expected from the cross-examination. Good or bad, we don't know what has happened, but the witness allegedly doesn't remember much. So these witnesses have turned hostile. there are different cross-examination techniques to examine different witnesses. There may be smart witnesses, maybe, clever witnesses. Now we say legal witnesses, let's say some companies have started to engage paralegal authorized representatives to be witnesses. How do we cross-examine them? But what we must discuss today is the examination of expert witnesses. Expert witnesses would be those who are defined, if not defined, who are examined in terms of Section 45 of the Evidence Act. Section 45 of the Indian Evidence Act. Expert witnesses, they are a very, very important part of a given criminal trial. In some cases, they may only be formal witnesses. In other cases, they may have a very important role. Again, by an example, how do we impute the credibility of a witness? See, expert witnesses are also neutral. They don't have any vendetta against the accused. They don't have anything personal against the accused. Now, what do we do about these witnesses and how do we go about cross-examining these witnesses? They are all important aspects. You must all understand, to cross-examine an expert witness, we can cross-examine them on the basis of their experience, the number of cases they have handled, or the number of similar cases they have handled, and on other areas of expertise that can also impeach their credibility as a witness. Now, what is it that we are doing? Let me give you another real-life example of one of our cases. Here, there is a patella fracture. It's a bone near the knee, patella. The allegation against the accused is that the accused, on one day, there was a verbal spat between the complainant and the accused. Accused bought a lethal, if not a lethal, I think a bamboo stick, and used that bamboo stick to break the patella bone in the knee. So there was a blunt weapon which was used by the accused to attack the complainant, and this blunt weapon was a bamboo stick. This bamboo stick could not be recovered by the investigating officer, and therefore the knee had been broken. Now, doctor, see, I can fight the world. As a defense lawyer, I can cross-examine anybody. But the doctor here in this case, on his medical certificate, a government hospital doctor, stated that this injury is due to a bamboo stick, looks like an injury pertaining to a blunt weapon, and the patella has been fractured, and 3 screws, this, that, and the entire medical history, and the victim has stated this, that, and all those things. You would feel that your case is over because an expert witness has now testified in the court about the accused using a blunt weapon to attack the complainant. And the case of the complainant was that the fight indeed happened, a verbal fight. But while the complainant started to run, the complainant had a fall on a concrete floor. The weight of the complainant was on the upper side, and due to this fall, there was a fracture, and there was no blunt weapon, and in the case at hand, no blunt weapon had been recovered anyways. Now, my first question to the doctor was, how many cases have you examined like this? He says, I'm comparatively new. This is my 8th or 9th case. I asked him, are you a trained physician? Are you a trained orthopedic surgeon? He says, no, I am a general physician. I was on duty that day, so I had signed the MLC. Understand that I'm impugning his expertise to understand the breaking and unbreaking of patella bone. You would understand that only a trained orthopedic surgeon would otherwise be equipped to understand the science behind the broken patella. Am I making sense? Whose domain is bones? Let's say you have ballistic experts who would, give their statement or expertise on ammunition, arms. have studied. I've dealt with so many cases under the Explosives Act, Arms Act, on behalf of Delhi Police. We've been giving opinions and all. The relevant expert must have complete expertise in the subject matter. Here, a general physician had signed a report where a broken bone was equated to a blunt weapon and his expertise was impugned. So his credibility is half gone the minute he says he was a general physician, because you have to understand the witness, check the credential of the expert witness and hit their credibility. Here, I asked the doctor thereafter, is it correct that your hypothesis is based on the narrative of the complainant? He says, yes, sir. If the complainant comes to us and tells us that so and so has hit us, that is how our conscious mind works on the facts. That is how we think the situation works. This doctor thereafter said, and I asked him that, is it also possible that this similar injury, although you are not an expert, that this injury may have very well been an outcome of a fall on a concrete floor? And the doctor says, yes, it is completely true. This may have been an outcome of a fall on the floor. You see, participants, that the idea of cross-examination is to impeach the credibility of the witness and to also explore alternate hypotheses where possible. Alternate hypothesis may be in tune with the statement or the version of the accused as well, like I just narrated. Impeaching the credibility of the witness, you have to have a very serious demeanor. You have to understand that this is no joke. Cross-examination is all we have. And by asking irrelevant questions, by asking questions which have no material bearing on the facts of the circumstance of the case, we are technically ruining the case. There have been cases where counsels have started to argue with the witness. Never. A great counsel who's prepared, a counsel, whether great or not, to be honest, who is well prepared, would never argue with a witness. There is a tendency of the witnesses lately to start arguing with the counsels. You have to avoid all these discussions and arguments. You are not supposed to argue with the witnesses. Also note that asking irrelevant question can very well may jeopardize our own case at hand. We may end up asking questions which are neither relevant or which do not have any material bearing on the facts of the case. Whereas the witness may actually end up saying, so now in one of the cases I had read, the counsel for the accused had asked so many irrelevant questions that other offences which were not a part of the final report in the form of FIR or charge sheet had also come out in the public domain in that case. Or other material facts which were not or should not have been. So you have to understand the consequence of every question that is being put forward. And it's very, very important that is done. Objections and suggestions are equally important. When do we object as defense lawyers? As defense counsels, we object when leading questions are put in the examination in chief. When a private lawyer engaged by a prosecutrix or a complainant, instead of aiding and assisting the prosecution during cross-examination or examination in chief, starts to play an active role, we object. These are certain things you will understand when you study the subject matter in great detail. And the prosecutor objects when the conduct or the questions of the defense counsels overreach the threshold beyond which we are not allowed to put questions. Let's say in the case of sexual assault, the number of times somebody had been intimate is an irrelevant question. These questions should not have any material bearing. As we say and study, consent is always a recurring phenomenon. It cannot be granted once for life. It cannot be, it's a continuous process. Therefore, in a case of rape, for instance, I've time and again seen counsels ask questions which are impugning the character of a lady. These questions should be deterred, should never be asked, should never be questioned. Again, you end up losing your own credibility as a counsel because these questions should never be asked. Therefore, asking the right questions, understanding the facts, understanding the environmental factors surrounding those questions, understanding the holistic story surrounding those questions, see if the accused has an alibi. In one of the cases, the offense had been alleged to have taken place on a certain date, but the accused was physically present in Shimla, Himachal Pradesh. He had a booking, he had some, camera footages of the hotel where he had stayed. Therefore, there was physical impossibility of the offense being committed on that date. And in such cases, although one should also try for quashing, these are very important questions which should be put forward on the basis of the alibi. There's a manner in which you cross-examine IOs, investigating officers. Tomorrow, we will also have a look at some cross-examinations where I have conducted a series of cross-examinations in bank robbery cases where we had been able to get an honorable acquittal. We will show what an examination chief was and how a cross-examination in this case was committed. We will also look into some special trials where I have cross-examined younger victims of alleged sexual assault, cases which are now complete and over, where acquittals have happened, discharges have been made from an academic point of view. We may also look into other special and general penal laws. We will look into a few cross-examinations and examination chiefs, including some examinations of expert witnesses, and then take a question and answer session on that subject matter. But today, the idea was to provide you with a brief insight into the process, a brief insight into how this entire procedure works. And before I open the floor for questions, I just want to elaborate on suggestions. Let us say that the witness is an expert or a smart or a clever witness, and the witness doesn't want to tell your narrative to the court. The witness is smartly playing with you. There is a concept of suggestions. You can always give suggestions to the witness and it is recorded. That is for the court to read when the court is framing the judgment. That is to show the story where you are leading, because see, the courts do not know where your leading question goes. You have to give suggestions here and there. And the purpose of the suggestion is to highlight as to what had happened according to you also. So you can say that this allegation of sexual assault, is it true that there is I would say that, my suggestion to you is that you have only leveled this false accusation on the accused because your husband had to pay a liability of 50 lakhs to the accused. She will say no. Then a statement will be recorded in the examination. No, it is wrong to suggest that 50 lakh rupees was payable to the husband or to the accused by the husband of the complainant and all. Although it may appear to be a useless question, but here we are giving some sight to the court that this is precisely what may have happened. And this is what we are elaborating on. So students, we will discuss the practical aspect tomorrow, but if there are questions on specific questions on theoretical part, and lastly, I just want to highlight there's a concept of refreshing the memory of a witness under section 159 of the Indian Evidence Act. There is a substantial time frame between which the statement is recorded and the trial takes place. In such cases, the witnesses are allowed to scroll through the judicial file or the court file, and they can very well go through their statement and the record. And this is known as refreshing the memory of a witness. Therefore, the witness is not supposed to keep everything, in a revision format in their mind. Ki every day they wake up and they start revising things. Ki mera 2 saal baad cross examination hoga. That is not how it works. There is a process in terms of Indian Evidence Act to do the needful. And we will also look at an examination in chief where this has happened and understand what had happened there. Now let's take some questions for next 10-15 minutes.
Yes, so all the participants who have a question, you can just raise your hand. We'll call out your name and you can unmute and ask the question too. So,
Good afternoon, sir.
Good afternoon.
My name is Nidhi, and my question is regarding the time. Like, is there any particular right time in a case for cross-examination or so? Or does time plays any role in the process of cross-examination?
And Nidhi, I think your question is directed to understand as to when the cross-examination happens. So there is no timeline as such. As and when the charge sheet has been filed and the court starts to summon the witnesses, the cross-examination happens. This may very well happen in 6 months, or it has happened in 10 years in some of my cases. So there's a timeline. There is no definitive timeline, but this process is predictable. It usually happens after the framing of charges. Yes, please.
Thank you, sir. Sir, one more question. Like how to differentiate between the relevant questions and irrelevant questions while preparing for the cross-examinations?
This is a very relevant question, Nidhi. Don't you think so? I think you must. So when you asked this question, you knew that this question was relevant. And there is no litmus test to know whether that question is relevant or irrelevant, but you have to think of the answer in advance. If you think the witness will not give an answer which will support your case, if you have a doubt in your mind that the witness may say something else, then the question is on the other side of relevancy, that it may not be a very relevant question. But if you feel that your leading question can lead to your hypothesis, that is where the relevancy test goes. So that is how you ask all these questions.
Good evening. Thank you so much.
Good evening, sir. Excellent first session. Thank you. I'd like to touch on your last point of refreshing the memory. So you have a witness. In refreshing the memory, you can ascertain the position of this witness has changed suddenly. Is this the area you would impeach them then? If you could just elaborate briefly on that.
Right. See, Jennifer, the question, the concept of refreshing the memory of a witness has nothing to do with the cross-examination. It has, in fact, to do with the examination in chief.
Okay.
Let's say I, as a witness, recorded my statement before the investigating officer, somewhere in 2015 or 2018, and then the Corona lockdown happened. Now I'm being called to I'm being called to the witness box in 2022. There is a time difference of 4 years between my statement being recorded and me appearing before the trial court for deposition as a witness. Now, to overcome this delay and to refresh my memory, because there may have been some peculiar facts which may have been highlighted during my statements to the investigating officer. Witnesses are not expected to remember everything for 4 to 5 years, 10 years, 1 year. They can always go to the court and say that this is my right. There is a provision under the law, section 159 of the Indian Evidence Act, which says that I am allowed to refresh my memory, so they can briefly read the file, speak to the prosecutor,
Okay.
and then testify. So the idea is to empower witnesses to remind themselves of the facts which have been highlighted when this entire episode happened and when the entire evidence was collected and the statement was given to the investigating officer.
Okay, got it. One final question, if I may.
Yes.
So similar as you touched on jury trial, is there such a thing as closing arguments, or it's that one-shot deal that you talked about?
No, see, I mean, we had jury trial in India till I think 1966, the KFP and the Nanavati trial, where this entire system was abolished. There are always opening and closing arguments everywhere. So, in terms of common law countries, I can tell you I've been to courts in Canada, US, UK. We always have the concept of opening and closing arguments. So here we have final arguments in India. We call them final arguments, and they are in a form of a closing argument. Well, this concept was in fact, created for jury trials because jurors were again lay people. They were citizens and they were common people who would not have deep insight into law. But again, the emotional statements would again have some bearing on those witnesses, but we have closing arguments here as well, the final arguments, which allows us to sum up all the evidences and highlight narrative which favors our case. So that is what we do in our closing arguments or final arguments, as we label them in India.
Okay, thank you, sir.
Sir, I am Furqan Akram from Kashmir University. Sir, I have 3 questions. I will,
Yes,
sir,
please.
ask you, yes. Sir, when can we say that the evidence adduced after cross-examination has lost its credibility? This is the first question, sir. Second question is, what is material contradiction? Please give some examples about that. And what is shaky evidence? When can we say that the evidence has shaken while a cross-examination?
Furqan will go one by one. Otherwise,
Yes.
I will have to refresh my memory on the questions that you had asked me.
Sir, first question is, when
let's
can
start with the first question.
Yes. When can we say that the evidence adduced after cross-examination has lost its credibility? When can we say that?
So that is not for us to say. That is for the judge to decide, obviously, whether the witness. But you have a feeling. See, as a defense lawyer, I know that we have done a good job. So in the case, if you remember, I had highlighted that the shopkeeper had then said that, yeah, you are right. Maybe I have mistaken the identity of the accused because there was a difference. That all those things were there, right? Now, Furqan, you would also understand that so far as this aspect is concerned, am I audible?
Yes, sir. Yes, sir.
You would know that you have done a good job in cross-examination and the credibility of the witness has been impeached. Sometimes you can ask similar questions to other witnesses. Prosecution makes a very common mistake. Let's say that there are 3 witnesses who had seen the accused stab the complainant. They usually end up writing names of all 3 accused, and it goes in your favor. You can ask memory specific questions to all 3 witnesses and they will all come out with different answers. One will say the accused was wearing a white shirt, the other will say pink, the other will say black, and they are all witnesses to one fact. Therefore, I've always been training my officers at Delhi Police, always put the most relevant witness for one fact. Do not introduce more than one relevant witness for one fact. Therefore, this answers your first question. Now, what is the second question?
The second question is, what are material contradictions? And please give some examples about that. I have so confused.
Yeah, see, material contradictions, again, it's a theoretical concept that we end up studying now. Material contradictions which deviates from the hypothesis of the prosecution, like a contradiction. This is self-explanatory in nature. It's material contradiction when the fact which was being highlighted by the prosecution has been contradicted. That is a material contradiction which draws an alternative hypothesis. Means the story has basically now deviated from what it was supposed to be. Do you get it?
Yes, sir. Sir, now one more question about this.
Where in Kashmir are you? Where do you study?
Kashmir University, sir. 6th sem, sir.
Very good. Next question.
BLLB, sir. Sir, दूसरा question, if in while statement under section 161 CRPC, they have said that we lodged an FIR on one date, but while cross-examination, they are saying another date, and they say that we filed FIR after few days because of loss of consciousness. When I hit by somebody and I lost consciousness, that is not corroborated by medical evidence. So can we say that that is material contradiction at that time?
See, Furqan, 161 statements you will understand are not signed.
Yes, sir.
Understand?
Yes, sir. They are not signed. Yes, true, sir.
Now, when these witness statements are not signed, you can't really, and you know, these are not material contradictions. You will understand that there are several judgments of the Supreme Court that, okay, this will have some impact, but minor discrepancies of this kind can be overlooked if in entirety the case seems to be. क्या होता है ना फुरकान, जब केस पूरा का पूरा दिखा रहा है कि वो इंसान ने क्राइम करा है,
Yes, sir.
उस केस के अंदर एक आधी चीज छोड़ी जा सकती है, ठीक है?
जी सर. जब सर अगर बोला होगा कि I was out of consciousness, but that is not corroborated by medical evidence. What can we say about that, sir?
See, in these cases, then you have to look at the case in entirety. You have to see the entire case in detail.
All right, sir. What is that is shaky evidence? What is that in short brief? That I understood now.
It's just evidence. One has to see the entirety of evidence. ठीक है ना? Tomorrow we'll use some of these examples. You will understand better. ठीक है ना?
Thank you very much, sir. Thank you.
Keep studying well and hard. Continue this way. Good.
Thank you very much, sir.
Sir, may I?
Yeah, go ahead.
Okay, so sir, I have two questions. So the first one is is there not a threat of like backfiring the cross examination? Like you are cross examining someone, and like it's not went go as you thought of it, and it's going to backfire you. Like,
Preeti, are you also a lawyer?
ma'am, sir, I am a student. Like I'm a second year law student. Yeah.
Okay, I thought you might have done a cross examination where questions have backfired somewhere. But
No,
anyhow,
sir. Yeah, sir, I have an interest in this field. So yeah, that's like.
No, it's okay. It's okay. See, there are times when things backfire. The other day I was trying to, so we have devised a technique here. I usually, so when the witness can neither say yes nor no, you are stuck because your leading question, you are expecting either a yes or a no. But there are witnesses who are sitting like this. You don't know. And then I have devised a formula that I can neither accept nor deny. I usually say this. That correct? Is it okay if I say this? That I can neither accept nor deny? Witness like, okay, I can neither accept nor deny. So what you end up doing is, effectively, is to say that the witness was deliberately concealing something in that case. But there are instances where, we goof up. It's a mistake, but you get to correct it somewhere later on. Try and correct it. Don't be scared. ठीक है ना? Don't worry.
Okay, sir. Okay, sir, my second question is like, I think these things are like art. So how we can learn? Like, I do not know much about it. So
Go to the court more often as a law student. If you see any cross examination happening, just stand there. Be shameless.
Okay, thank you, sir. Thank you so much.
Most welcome.
Sir,
Yes, Iman.
my name is Aman Nahar. Sir, I
Iman.
wanted to ask that earlier.
Everybody today has a wonderful name other than me. It's a very common name, Sanjay. Everybody has it. But other names are all very nice. Go ahead, Iman.
Sir, you said earlier that questions on character of a woman under section 376 can't be asked. But sir, isn't the previous character of the person is relevant under Evidence Act?
The law is well settled in this regard, Aman. The way it works is that if the accused is giving a good character evidence, accused is coming to the court to say, no, I don't have any prior conviction, I'm a man of great integrity and character, then only bad character evidence is relevant. This is settled law. However, if the accused does not give good character evidence, then his previous bad character has no bearing on this trial. Agar ek accused hai, let's say there is an accused who has been apprehended of stealing motorcycles and cars in the past. 5 years down the line, there has been some theft and the investigating officer makes an arrest. He is the one who has been doing it in the past and he has done it again. Previous convictions and all those things will have no material bearing in terms of Indian Evidence Act. But if the accused comes and says that no, I am so innocent, I have never committed such, then only a bad character evidence matters. Okay?
Sir, but I'm asking about the victim.
In a rape case?
Yes, sir.
No, there is no question of any past character evidence. There is no question of any past anything. Even, let's say there is a sex worker for that matter, the consent again has to be a continuous process. One can't say I had taken a consent 1 year ago or 10 days ago or even yesterday or today. Do you get it? In that example also, past experiences have no material bearing. We have debates going on marital rape in Delhi High Court.
Yes, sir.
Let's understand that. It's a very sensitive topic. Yes.
Sir, this is Dhirendra Kuber here. I have a question regarding the presumption in Evidence Act. See, these days, many false POCSO cases are coming about. Am I audible, sir?
You're audible. Many false cases are coming.
How do we? Yeah, I mean, some one or the other will be knowing that's a false case. But however, there is a POCSO case. There are statutory, punishments for that. But how do we overlook or how do we overcome the presumption in a cross-examination? Because there is only one sole witness.
In POCSO, Dhirendra, in POCSO, Section 2930 reverses the onus. There is a presumption of mens rea and actus reus, the guilty mind and the guilty act in the POCSO law, right? Now, so far as this presumption is concerned and all these false cases are concerned, see, there is a very thin line difference between a case which is false, which is disproved, and which is unproved. Do you understand? Not necessarily that every case of acquittal is false.
True.
And so we don't need to overlook if you feel that a case is completely malicious, maybe after the acquittal, start a proceeding of perjury.
No, I mean, this may be off the track on this topic of cross-examination. See, these days what's happening is because of the amendment in the IPC, any man who has completed 15 plus years will be treated as an adult, whereas the woman who is 15 plus is not, and she is still a child. So this is the reason why college-going children are framed in a lot bigger number.
No, but Allahabad High Court had recently said, see, I mean, that is how the law is. We can't really debate about the law. But the Allahabad High Court, I think last week said that the intention of POCSO law is not to prosecute young adults going to schools and colleges.
Yeah, well, I mean, the question now regarding to this course is how do we cross-examine a child witness?
We will discuss tomorrow.
Because
we will show you an example. We will show you an example tomorrow.
Sure, because it's all done under cloak and dagger.
We will show you. We will show you a real life example.
Sure.
Good afternoon, sir.
Good afternoon.
Sir, I am Abul Hassan. Thank you for your elaborate discussion. Sir, I have three questions. First is, sir, how to bring contradiction on record while cross-examining a witness and prove it through IO?
How do we?
How to bring material contradiction on record while cross-examining a witness and to prove it through investigating officer?
I will have to cross-examine you to ask this question again. So let's start your cross-examination. No, see, ultimately you have to individually cross-examine Abul. You have to cross-examine each witness one by one. But you can always relate. I get your question. Let's say in one of the cases, the allegation of rape happened inside a one-bedroom flat where the complainant alleged that no, we used to stay together, but after 2 months of staying together, he came to me on my bed and started lying down with me. Now, the fact of the matter is that it's a one-bedroom flat, a studio apartment, there's only one bed. So the whole question is that the accused was not having any other place to go to bed at. Now, in this room only had one door. I had asked this question, is it correct that there is only one door, which is a Jalidar door, the one with the net, iron net? The complainant says no. The investigating officer says yes, because she has made that graph and all those things. So this is just an example. So we individually, but we can always connect the question and all. You get it?
Yes, sir. So my second question is, sir, for example, while cross-examining a witness, we are putting questions to the witness, but he is not giving the answer in the direct way, but he is explaining more than I want. While I raising objection to the judge,
You tell the witness to stick on the question. I always tell the witness. You say, see, I'm asking you a question, stick to the question, don't. And you can always request the presiding officer of the court, judge, to moderate the examination. We are not saying that we can, put a cloth on the mouth of the witness. That is not the way. But you can therefore ask pointed questions where the answer is going to be of limited extent.
yes, sir. Sir, my last question is, sir, how to use rigor mortis to dispute the time of death while cross-examining an expert witness?
That is a part of the medical. If you see the stiffening of bones, rigor mortis happened. Let's say that the time of death, what happened in Sushant Singh's case, the whole issue was of the rigor mortis only. What is rigor mortis? It talks about the time where the death may have happened. Sometimes again, rigor mortis or stiffening of bones is different for different geographical locations. We had a friend from Kashmir, and then there may be a friend from South India. The weather conditions would make rigor mortis set in after some time. If you read medical toxicology, in such cases, rigor mortis may directly challenge the story of the investigating officer or the FIR. If the FIR says that the death had happened at 3 p.m. on 5th January, medical was conducted at 8 p.m. on 5th January, which says that the rigor mortis had set in for 2 days, for around 48 hours. Then the hypothesis of the prosecution fails because the death had happened 2 days before the FIR got registered. Then you can ask these questions to the investigating officer and including the doctor. Okay?
Yes, sir. Thank you, sir. Thank you also so much for all the co-hosts. Thank you.
Thanks, sir. This is Furkan once again.
I think one or two last questions if somebody else. I think Furkan will discuss more from you tomorrow. But,
Sir, one question only. One.
There are other witnesses,
Okay.
other participants.
Yes, sir. Okay. Let them ask, sir.
You are at a beautiful place, Furkan. Relax there.
Okay. Thank you very much, sir.
Any other question?
Good afternoon, sir.
Good afternoon.
So myself, Komal Agarwal. Sir, I wanted to know, I have studied silence is acceptance. So what will be the consequences, or what does your experience say about being silent, either by the witness or accused or complainant regarding this during the cross-examination?
See, there is nothing called silence is acceptance. It doesn't work that way. I was just telling you that there are witnesses sitting like this, and we say the witness can neither accept nor deny. And there can be adverse inference of certain facts. Inference may be drawn कि शायद ये fact ऐसे है या वो fact वैसे है. But there is no concept of silence is admission. In certain cases, it may be the case that silence is admission indeed, but that is not always the case. So remember this.
Sir, so what will be the consequence or answer if a person is silent?
You get it recorded in the cross-examination that the witness doesn't want to answer. The witness remains silent on the demeanor of the witness. And let's see how that is interpreted at the outcome.
Okay. Thank you, sir.
Most welcome. One last question.
Just a small announcement to the participants. So we'll only be taking 2 more questions from the participants. Yeah. So whoever has a question, just raise your hand and you can ask your question.
Hello. I think Srijana Bahadur has a question.
Yeah. Yes, sir.
I see the hand.
You can please go ahead with your question.
Or Puneet Agrawal. Go ahead. Whoever has a question.
Sir, hello.
Bolo Vijay. Go ahead.
Sir, can I talk in Hindi, sir?
You can talk in any language. I will try to understand them all. Go ahead.
हाँ, अभी जो डिस्कशन हुआ है इसके बारे में कि when can we say the evidence is reused, अभी जो क्वेश्चन पूछा है reused evidence के बारे में, तो अगर मेरे ऊपर एक चेक बाउंस की केस है और एक ओथ विटनेस है कि जिसने पहले भी ऐसा एविडेंस दिया है, फॉल्स एविडेंस, तो दूसरी बार भी चेक के बारे में उसने एविडेंस दिया है कि ये चेक फॉल्सफुली इसने ये केस रेज किया है, तो उसमें
एक सेकंड रुको विजय, एक सेकंड रुको। क्या होता है कि एक तो ना चेक बाउंस के केसों में विटनेसों का कोई ज्यादा रोल नहीं होता। वो एक फैक्ट होता है कि किसी का चेक बाउंस हुआ है और कंप्लेनेंट ने क्या कहा है कि फाइनेंशियल लायबिलिटी क्यों थी, क्योंकि सेक्शन 139 नेगोशिएबल इंस्ट्रूमेंट में एक लायबिलिटी होती है, ठीक है, 138 की, ठीक है। इसको हम स्ट्रिक्ट लायबिलिटी ऑफेंस कहते हैं। तो सिर्फ डिफेंस मैटर करता है। तो वो कोई विटनेस कहीं से आगे कह रहा है कि ये झूठा ही चेक दिया था, उसकी कोई रेलेवेंस नहीं है इतनी। जस्ट रिलैक्स, ठीक है, अपने डिफेंस पे फोकस करो।
नहीं सर, आपने तो करा है कि जज के ऊपर डिसीजन करता है कि उसने एविडेंस दिया है फॉल्स एविडेंस, तो वही केस में उसके ऊपर कुछ एक्शन नहीं ले सकते हैं?
लेना, पहले एक्विटल करा लो। आपका एक्विटल हो गया अभी?
अभी ऑर्डर के लिए है 15 तारीख को।
तो अब 15 के बाद मेरे से पूछना, मैं आपको आंसर बताऊंगा, ठीक है?
ओके, थैंक यू।
नेक्स्ट, लास्ट क्वेश्चन। यस।
Hello, sir. My name is Naman Tegam and I'm a fourth year student at Symbiosis, Hyderabad. And my question relates to subsection 3 of Section 155 Evidence Act, which is one of the ways to impeach the credit of witness by proving inconsistent formal statement. Now, I've always considered this formal statement to be 161 statement, the statement according to given to police under 161. Sir, can we prove a formal statement of a person by an independent witness, an oral? Let's say a person make an oral statement to anyone. Can that witness come and testify that yes, he made a statement to me, and on that basis we can impeach his credit?
Repeat the last part. On the basis of 161 statement only we impeach the credibility.
No, sir, not the 161 statement. Can we impeach the credit of a witness on the basis of on the basis of testimony of an independent witness?
But how is the independent? Naman, see, the only way a witness is in the court is through the list of witnesses in the charge sheet. The way it works is that the charge sheet will have the list of all the witnesses. Otherwise, the defense will get an opportunity to give their list of witnesses. Okay?
No, so I think, sir, I've terribly failed to explain my question.
No, I may have terribly failed to understand your question, but I'm just saying that independent witnesses, yes, you can always, okay, I think I get it. Yes, independent witnesses can again disprove the statement of a witness otherwise who have already appeared if there is a contradiction and a material contradiction, because all of these are prosecution witnesses, correct? In your case,
sir, could be defense.
So the defense witness, why not? So defense witness will have to prove. Then the test of the prosecutor comes into picture. The prosecutor will have to showcase his or her skills and to impeach the credibility. Then you get it?
Okay, sir. To conclude, so an independent witness can come, give a statement, prove in the court that an accused makes a statement which can be used as a formal statement under section 155 clause 3, and then therefore it can be used to impeach credit of the witness. As you said, if there's a contradiction.
Again, it has to be seen in entirety. Remember that. ठीक है ना? सारी चीजों को पूरे में देखना होता है. Entirety, how it flows in the end. All the witnesses together. Tomorrow I'll try to get a real life example on this. ठीक है?
Okay, sir. Thank you so much.
Most welcome. All right. Thank you, everyone. We'll catch up tomorrow. And
one more question.
Wonderful interacting. Abhishek, we'll catch up tomorrow. I have a conference starting in 2 minutes.
Okay,
so we'll meet tomorrow. Thank you, everyone. Thank you.
Thank you, sir. Thank you, sir.
Thank you, sir.
Thank you so much. sir.
हेलो हेलो
Hello. Yes, sir.
हाँ मैडम जी, अच्छा सर ने अच्छा गाइडेंस किया है, एक्वाडल करा लो आपने पहला। मैंने जो क्वेश्चन पूछा था यहाँ पर अभी, तो सर ने आंसर अच्छा दिया और आपने जो ऑर्गेनाइज किया है प्रोग्राम मुझे अच्छा लगा ये।
Thank you, sir. Thank you for your feedback. We hope you will be
और
joining
हमें
tomorrow also.
हाँ हाँ, लेकिन और भी कुछ क्वेश्चन है रिलेटेड की, मतलब लाइव क्वेश्चन, मतलब तो अभी मेरा जो केस चल रहा है उसके ऊपर हमने सर को क्वेश्चन पूछा, सर ने अच्छा दिया आंसर किए, आप एक्वाडल करा लो अपना। तो और ज्यादा कुछ क्वेश्चन है थे उसके बारे में, लेकिन टाइम बिंग और ये जो टाइम बिंग की वजह से नहीं पूछ पाए, तो कुछ टाइम बढ़ा सकते हैं कल।
We'll look into that, sir. We'll see.
ओके ओके सर, ओके ओके, थैंक यू। अभी क्रिएट करना है सर इससे। हेलो,
Yeah, hello.
डिस्कशन कंटिन्यू चाहिए, चालू रहेगा या क्विट करना है?
For today, the session's over. We'll be continuing tomorrow at the same time when it started, 3 p.m.
Okay, 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 okay. Thank you.
Yeah, thank you.
Thank you.